Hi, my name is Jennifer Solak, and today's topic is going to be what is probate. I am an estate planning and probate attorney in Texas and Louisiana, and when we're having estate planning conversations or somebody has to go through the probate process, a question that often comes up is, what is probate? And it's a great question, and a lot of people, if you haven't had to deal with it, rightfully do not know or understand about the process. So hopefully today's video will help unveil some of that and shed a little bit more light on what exactly is involved in probate. We're going to talk about what it is, what assets go through probate, and some of the costs that are involved. So what is probate? It's essentially just a court-supervised process that is used to transfer title to somebody's assets when they're no longer here to provide their signature. And typically, they're no longer here because they've passed away, but they might also no longer be here in a sense because they're alive but unable to manage their own affairs. And in that regard, they might need a guardian appointed of them in court. But in getting to where somebody has passed away, then what is involved in probate, there's certain assets that go through probate. So the biggest one I would say is real estate. If somebody owned a real estate, the court needs to appoint someone to act on their behalf to transfer title to that real estate. Other things that go through probate are non-retirement or non-life insurance investments that the person who is deceased held. And another common item that goes through probate are business interests. If the person who is deceased had any ownership in a company and there wasn't a clear plan of what should happen with that company, those business interests typically go through probate. There's also certain assets that are exempt from probate and typically don't have to go through the process, and those are more contractual based assets, and those assets typically pass to whoever is listed as the beneficiary of those contracts. So those assets are usually retirement accounts, life insurance, annuities, or maybe it's a bank account that has a POD or payable on death beneficiary. Those can typically pass outside of probate. Another type of ownership that passes outside of probate is joint tenancy with right of survivorship. This exists in Texas and not Louisiana, but if you're in Texas and you own as a joint tenant with right of survivorship, it's important to understand that that asset is going to pass immediately to the surviving joint tenant. And maybe that's great, maybe that's what you wanted. If you owned a house with your brother, you wanted it to go to your brother, and it's great. That house will go directly to your brother and can avoid probate. But maybe it was your intention for your half or your ownership interest in that house to pass to your family or pass to the beneficiaries that you've listed in your will. And in that context, it's important to understand that if you own as a joint tenant with right of survivorship, it won't go to the beneficiaries you wanted it to go to. It will go to whoever is the surviving joint tenant. So when having the planning conversation, it's important to understand how you hold title to any kind of property. And finally, when talking about probate, there are costs involved. There's costs in time and costs in money. And if you have a will in advance, you still have to go through probate, but there will obviously be less cost and less money. But it is important to understand in the probate process that while you are waiting for the court to appoint somebody to act on behalf of the deceased assets, those assets are frozen and nobody can access them. They can't sell the real estate. They can't get the money that might be needed to close out some other affairs. And so that holding period, that frozen asset period, is just something to know about and weigh in consideration of whether probate is something you want your family to have to go through or not. There's also fees involved in probate. So there's, of course, court costs. There's also attorney's costs. Your family, if you have a will, needs to hire an attorney to take the will through court for you. And if you didn't have a will, there's the court that your family has to hire, and then the court also appoints an additional attorney to resolve itself that there are no unknown heirs out there. That's called a court-appointed attorney or an attorney ad litem, and so that's an additional attorney that your family would have to pay for. There's sometimes appraisers. Sometimes a court will waive appraisal fees, but sometimes they won't, and they will require that appraisals be had of the inventory of the assets in the estate. Sometimes the court also requires that a bond be made for whoever is appointed to manage the affairs. And finally, there's an executor fee to consider. Texas law and Louisiana law both state what a reasonable fee for an executor is. In Texas, it's 5% of the probate estate. In Louisiana, it's 2.5% of the probate estate. Some executors take it, some don't, but just something for you to be aware of, that the law does allow them to take a reasonable fee. And when you're considering the size of your probate estate, it is important to consider that your assets are valued at their fair market value. So for example, if you have a $500,000 house and you have $100,000 of equity in it, that house is going to be included at the value of $500,000 when valuing your estate. So I hope that you have found some of this information helpful, and if you ever need to reach out to our office, you can call at 713-588-5744. And I ask that you please hit the subscribe little bell below. That will help us to continue making more videos, and it'll help YouTube know that this was helpful and more people should see it. Thank you so much. Bye.